Hello, class, and welcome to Module 2. I hope you all had a good week and have done the reading and have begun to appreciate what the class is all about. In our second week, we'll get a little bit more specific and use some real world examples for how our United States Constitution uh, plays into the debate on public health powers exercised by the government and the conflict between those powers and individual liberties guaranteed in the Constitution. So, in Module 2, we will look at some of the constitutional provisions which are most often implicated in public health initiatives, and those will be the First, Second, Fifth, Eighth, and 14th Amendments to the Constitution. Once again, I've given you in the introductory materials a resource, the United States Constitution. I want you to become familiar with it so that when we refer to these amendments or provisions, you can very easily look them up, read them for yourself, and ask questions about them if necessary. We will also this week begin to look at actual judicial decisions. And although we're used to hearing news personalities tell us what these decisions mean, I hope to give you enough of a background so that you'll be comfortable actually looking for these opinions and reading them yourself, if not the whole things. A recent one in Wisconsin, for instance, was 116 pages long, but I will give you some shortcuts so that you can get right to the heart of the matter and figure out what the holding of the court was. So we'll learn a little bit about how to begin to read and understand judicial decisions. And we'll also look at a very important case in the public health law field, Jacobson versus Commonwealth of Massachusetts, decided by our United States Supreme Court 115 years ago, and it's still good law today. And I'll show you how in a recent Texas federal court case called In Re Abbott, the Jacobson decision was cited as authority, and I'll explain why it is that Jacobson, 115 years later, is still influential in the field of public health law, as it decides the authority of the state of Texas to limit, in this case, abortions as part of its public health response as non essential surgery. So, coming out of this module, I hope that you will have gained an understanding of the provisions of the Constitution, which are the most important when we talk about public health. I hope that you'll gain an understanding of the role of legal precedent, that is, decisions of courts from the past, in the way the judiciary functions and limits the responses of government to public health and the outer limits of our personal liberties when they come into conflict with governmental actions, and also get a sense of how to read a judicial decision. I want you to pay special attention to the news as we go forward. You will find in the news that in places like the state of Michigan, there are protests on practically a daily basis where people are taking to the streets to voice their opposition to some of the measures that have been undertaken by state governments to safeguard the populace from the spread of the COVID-19 virus. So, this is in real world and in real time an illustration of the conflict between governmental power in the public health field and individual liberties. As with most areas of the law, in the public health law field, the law, the government, the courts are seeking to strike a balance, and the balance in this case is quite delicate. The balance is in the inherent conflict between governmental power to address public health concerns and individual rights and freedoms guaranteed by the Constitution. The limitations on governmental power in the public health field really fall into two categories. And the first category is what we would call rights based limitations. That is, limitations on governmental power which are defined by the liberties of the individuals affected by these measures and how they are limited or restricted in times of public health crisis. The other category of limitation in public health governmental power is the limitation of structural limitations. And by this we mean that in our system of federalism, as we discussed last week, we have a state government in each of our 50 states, and we have a federal government which applies across the nation. These two governments coexist and in most cases are able to govern, pass laws, and enforce those laws without coming into conflict with one another. But occasionally, and especially in the public health field, federal powers in the public health field and state powers in the public health field can come into conflict. When they come into conflict, we have to discuss what rules are we going to employ to figure out which of the two laws will prevail? On the one hand, we have the supremacy clause, which says that when a federal law comes into conflict with a state law, the federal law should prevail. On the other hand, we have the 10th Amendment, which is called the Reserve Clause, which is really the source of all state government powers. And under the 10th Amendment, we know that the state has both police powers and parens patriae powers, both of which come into play in a very big way in the public health field. For the most part, we'll find that public health efforts and public health governmental exercises of power should be exercised at the state level, and that the federal power to act in the public health field is limited to a couple of categories of laws and measures. And as we move forward, we'll see the boundary between the federal and state jurisdiction in the public health field. Rights-based limitations are limitations on governmental power which are stemming from constitutional protections of individuals from unwarranted governmental actions. Generally speaking, we talk about these core freedoms by beginning with an examination of the First Amendment. The First Amendment, and I would ask that you take a look at it as you go through the readings this week, protect us by guaranteeing the freedom of speech, the freedom of religion, the freedom of assembly, and many other rights, some of which are enumerated and others which are implied, although not enumerated. These core freedoms and these rights also include due process, which is protection from governmental actions which are oppressive, and also protection from discrimination or favoritism of one group of people over another. And this is called the Equal Protection Clause of the Constitution. The First Amendment applies to both individuals and corporations. And the first guaranteed freedom by the First Amendment is that of speech and expression. It covers political speech and it also covers commercial speech. When we talk about commercial speech, we're talking really about advertising, the ability of a company to advertise its product through any of the media. To a great extent, both political speech and commercial speech are protected. However, there are limitations on these protections. And in the public health law field, we'll explore, particularly as it relates to tobacco products, using that as the best example, that commercial speech can be limited by the government under the right circumstances. The right of assembly is also guaranteed by the First Amendment. This is the right of people to come together, generally speaking, to exercise a speech right, the right to make their feelings known. Think of political protests when we talk about the right to assemble and the right to political expression. But assembly has also come into focus during the COVID-19 crisis in the sense that when protesters who are complaining about governmental social distancing measures are coming together in a confined space, they are coming into conflict with the very same laws that they are protesting. So, on the one hand, the government might say that gatherings of more than 10 people are prohibited, and yet you might have hundreds or even thousands of people converging on a place for the purpose of protesting those laws. This is, again, a delicate balance. Freedom of religion is in focus. And it comes up in really two contexts in public health. One is in the vaccination debate. The anti vaxxers, on the one hand, fall into a category which says that vaccinations are medically harmful, perhaps the cause of autism. Although this has been largely disproved, there still are large groups of people who insist on the right not to vaccinate on the basis of science or what they would call science. Others, probably a more common objection to vaccination, make their objection on a religious basis, arguing that their religion prohibits the use of the vaccination. This is true in Orthodox Jewish communities, some, not all, and this is true in other religions as well. And we will explore in greater detail in coming weeks how religious freedoms and the public health measure of vaccination can come into conflict. Freedom of religion falls into two categories. One is the Establishment Clause, which doesn't often come into play in public health. This is the clause that says that government shall not establish any one religion. This means that in the United States, we will not have a state or an official religion of the nation. But the one which does come into play most often is the free exercise clause, so that if someone has an objection to a vaccination on religious grounds and says that it is a tenet of their religion not to take the vaccination, then a state or federal law requiring the vaccination could be argued to be in conflict with the free exercise of that religion. The other way in which religion and um, the religious freedom comes into play in public health has come up recently when state social distancing laws prohibiting congregations from coming together for worship have been objected to by churches and synagogues across the nation, with the protesters complaining and even suing in court, as we will see, that the social distancing measures come into conflict with their their guaranteed freedom under the First Amendment to exercise their religion. You'll see on the next page here a graphic of one of the protests in Michigan. This is the State House in Michigan. You can see the protesters. I don't see many masks on protesters here. I do see some weapons. I'm not sure how that comes into play. And I do not see a lot of social distancing. So this is an example graphically of what these protests can look like. The Due Process Clause is found in both the Fifth Amendment and the 14th Amendment of the Constitution. The Fifth Amendment and the 14th Amendment both provide that government may not deprive a person of life, liberty, or property without due process of law. Due process of law really has two meanings in this context. Number one is what we call substantive due process, which means that the laws that the government enacts may not be arbitrary or capricious or illegally vague. Procedural due process means that the penalties or the consequences of the violations of those laws may not be imposed without notice and an opportunity for the accused offender for a hearing, and that also implies the right to legal counsel. The 14th Amendment makes the Due Process Clause applicable to the actions of state government as well as federal government. The right to travel is not specifically mentioned in the Constitution. It is not an enumerated right. That is, it is not one which is listed in any of the 10 amendments of the Bill of Rights. However, it has been implied from the general liberties guaranteed by the Constitution. The government, it has been held, cannot prevent a person from traveling within a state or from state to state or residing in a state without justification. And now, in the midst of the COVID 19 pandemic and the measures taken by government, this comes into focus when we think about quarantines and highway checkpoints and other travel restrictions imposed by state governments. It also comes into play when we think about how the federal government has imposed travel restrictions on people coming into our country. Outside of COVID 19, the right to travel is implicated by sex offender registries, which have been challenged and upheld in many states, including the state of Florida. So that someone who is traveling and seeking to reside in your community may be listed as a in the sex offender registry, and this has been held not to offend the due process or right to travel liberties conferred by the Constitution. Another provision of the 14th Amendment is what we call the Equal Protection Clause, and it boils down to the fact that the government may not deny any person equal protection under the law. That's equal opportunities. It prohibits the idea that one group of people can be treated differently from another group of people. In the public health field, and we'll always try to bring these back into a public health focus because that's the nature of this class. Equal protection came into play historically when the governments sought to impose quarantines on certain segments of the population. therefore, back in the early 20th century, when a city would seek to quarantine a particular ethnic group, for instance, an Asian quarantine, this would be held to violate the equal protection principles of the 14th Amendment. Sometimes equal protection is apparent as the law is applied. And by that I mean it's not as easy as saying, well, it's not legal to quarantine only Asians, but sometimes the equal protection denial uh, is um, is actually implied from the way a law is enforced. So sometimes when we talk about zoning and affordable housing, we find that through the zoning powers that a government, a town, or a state have, they can actually deny equal protection of the law to a segment of the population. What about the church and synagogue closures? Could that implicate equal protection? Well, in a recent lawsuit filed in New Jersey, which we will try to follow um, as we go forward in this class, a pastor of a church in West Caldwell, joined by a rabbi from Lakewood, have filed suit in federal court. And they're claiming that Governor Murphy's social distancing protocols, his executive order, violate not only their religious liberties guaranteed under the First Amendment, but that also they've been singled out on the basis of their belief for different treatment, and that therefore their equal protection rights have been violated. It remains to be seen how the courts will treat these claims in the lawsuit, but we will watch it closely and we'll discuss any meaningful developments. This does not mean that the government cannot treat different people in different ways as long as there's a rational basis for distinguishing those individuals in the public health field. And this comes down to what we call levels of scrutiny. So, for instance, if we were to say that all people who are exhibiting symptoms of COVID 19 and have registered a fever should be quarantined, well, it would be okay to treat those people differently from people who do not have the symptoms because there's a rational basis for it. However, when the distinguishing feature comes down to uh, ethnicity or race or a religious background or gender, then a heightened level of scrutiny will be applied. The government will not be able to say, for instance, that all women should be quarantined or that only Latin Americans should be subject to travel restrictions. Those would require the government to show a compelling state interest, which is a very high standard in order to sustain that kind of a distinction. So, as a rule, when you read the executive orders imposed by the governors, you'll find that they apply across the board and, at least on their face, do not single out any particular group of our population for special treatment. Another right, which is guaranteed under the Constitution but not enumerated, is the privacy right. This is frequently implicated in public health initiatives, and most famously is the basis for the ruling in Roe v. Wade, which guaranteed the right of a woman to have an abortion. But in the public health field, and as we talk about the pandemic and the government response to it, we think of privacy as coming in three categories. One is bodily privacy. That is, that no one can be forced to take a treatment, a screening, or a testing without a compelling justification. Now, a compelling justification is not a high burden to prove when we're in the teeth of a pandemic. So certainly someone could be forced to be screened, I would think, when we have the threat of this pandemic with all of the mortality that we're experiencing. But there will undoubtedly be cases working their way through the courts on just this issue, and we'll keep an eye out for them. The second category of privacy is decisional. That's the right to make medical and parenting decisions. Quite often, this comes up in the case of vaccination, and this was the central issue in the 115-year-old Supreme Court case of Jacobson versus Massachusetts. The question is, can you force someone to take a particular medical course, a course of treatment, a vaccination? Can you force a parent to subject their children to a vaccination? What happens if vaccination is set up by state government as a condition for enrollment in school? This is certainly a coercive measure because most parents will seek to put their children into our public school system. However, the right to homeschool is also present. So decisional privacy will also be discussed as we go forward. And finally, informational privacy has to do with your medical information and HIPAA, HIPAA. We're all familiar with that. Certainly, you are being in the fields of study that you've chosen. You know that health information is not readily available to the general public. However, in the public health field, if someone presents with a public health condition, if someone is diagnosed with COVID 19, then your physician is obligated by law to report that to public health agencies. So there are limitations on the HIPAA right or the informational privacy right. Other rights which come into play, and one in particular which I think is very interesting, are the Eighth Amendment right or prohibition against cruel and unusual punishment. And generally speaking, this comes into play when we discuss our penal system. It requires that the state or the federal government, whoever the incarcerating government agency is, uh, supply competent medical care to prisoners. That's a fundamental right of all prisoners, regardless of why they happen to be in prison. In the COVID 19 crisis, you've read in the news about prisoners petitioning for release because they have pre existing conditions and because the prison environment in which they find themselves has experienced an outbreak of COVID, endangering their lives, or so their petitions would suggest. Along these lines, recently, Paul Manafort, who was convicted in the scandal regarding uh, the Trump administration, and also others have been released from prison specifically because of the COVID 19 outbreak and because of their medical condition. We will examine this in some detail, and possibly one of our case studies will touch on it. The right to bear arms is the Second Amendment. So one might ask, what does the right to bear arms have to do with public health? And I will tell you that in view of the recent spate of mass shootings, many people, many thinking people, believe that gun control or the failure to enact gun control has given rise to a public health crisis. The loss of life through these mass shootings is and can be seen as a public health crisis. On the other hand, we have the Second Amendment, which guarantees the right to bear arms. There is a very powerful lobby which resists any effort to control guns. and gun ownership. And so as a result, we have a major conflict here. Gun control measures at the state level have met resistance, and for the most part, federal gun control measures have been criticized by the courts. So we'll talk about that at some point. And then finally, takings, just compensation. The Fifth Amendment of the Constitution says that property may not be taken by the government without just compensation. We know that the government from time to time finds the need to take private property. This is happening on the southern border with President Trump's border wall. They're condemning vast swaths of property along the border, primarily grazing or ranching land. And the Fifth Amendment requires that they pay the owners of that land just compensation for the property, what that property was worth. It also requires that they show a legitimate public purpose for the taking. In the case of public health, many times there'll be a property in private ownership, which is a cause for public health concern. It's unsanitary, it's unsafe, you name it. Under those circumstances, the federal government or the state government may be able to step in to ameliorate the public health concern and take that property out of circulation. And in most cases, they'll be required to pay just compensation to the property owner when they do so. Okay, now that we've taken a look at some of the individual liberties that come into play in public health law and the ways in which governmental public health powers can come into conflict with them, let's take it down to a particular case. I want to talk about the Supreme Court decision in Jacobson versus Massachusetts, which is quite a famous case in the field of public health law. I don't expect that any of you would have heard of it, but if you did, I would say bravo. We're going to talk about it in terms of what it means in public health law today, and we're also going to use it as a way of exercising a new skill I hope to leave you with, which is how to read, at least at some level, a judicial decision for yourselves so that you're not reliant on other people telling you all the time what they think a particular decision means. You will have the tools, I think, to um, research a decision and read it yourselves. And you may not, because you're not law students, be completely immersed in the legal analysis that goes on, but at least you'll understand the facts that were before the court and the practical outcome, the decision. So, with that, let's jump into Jacobson versus Massachusetts. Um, well, first of all, Jacobson was a reverend with a church in Cambridge, Massachusetts in 1905. And Jacobson, at that time, living with his son, uh, were impacted by a state law, Massachusetts state law, and a Cambridge ordinance, which required vaccinations for smallpox. Smallpox was a big killer in American society back at the turn of the 20th century, and there was an outbreak in Cambridge. The Massachusetts law gave local public health officials the ability to require vaccinations in cases where the public need dictated that it was necessary. And in this case, Cambridge, acting on that authority, passed the smallpox vaccination ordinance. What the ordinance said was that each citizen of Cambridge would either have to submit to the vaccination or pay a fine of $5. Now, $5 sounds like a trivial amount today, but back in 1905, it was probably the equivalent of something more than $100 in by 2020 values. So Henning Jacobson refused the vaccination, claiming that he and his son had had bad reactions to other vaccinations. Not clear they were smallpox vaccinations, but that he and his son were having bad physical reactions to vaccinations generally. And for that reason, he refused. Cambridge then said, well, then you will be fined $5 for refusing the vaccination. Henning Jacobson then made an appeal to the Massachusetts courts, and his case ended up before the Massachusetts Supreme Court. And he argued again that he shouldn't have to take the vaccination because of the possible deleterious effect of the vaccination on he and his son. And he also made other legal arguments. The Massachusetts Supreme Court disposed of his medical arguments, saying that that's fine. If you don't want to take the vaccination for any reason, it's not necessary for you to tell us why. You simply pay the fine. Therefore, we're not going to decide whether or not someone with a medical condition could refuse the vaccination. It's not clear that Jacobson ever really made a strong case for the medical reason to decline the vaccination. But nevertheless, he took his case up into the federal system to the United States Supreme Court. And there the case was decided by the full court, but in a famous opinion written by Justice John Harlan. And Jacobson argued in the Supreme Court that the Cambridge Ordinance and the Massachusetts law, which authorized it, violated his 14th Amendment liberties. You'll remember from earlier in the lecture, we talked about what the 14th Amendment guarantees to citizens. And what it guarantees is a certain privacy right. Jacobson argued that the decisional liberty, the ability to decide whether or not to take a vaccination, was violated by this law. Bodily privacy is not implicated here, however, because the Cambridge law did not require that you take the vaccination, only that you either take the vaccination or pay the fine. So it's not as if he could have been arrested and pinned to a table and injected with a vaccine. That then would have implicated his bodily privacy rights. But here it was decisional. And although, yes, he still had a decision, the decision to vaccinate or to pay the fine, the decision is coerced by the fine, and therefore the court considered seriously his argument that the vaccination ordinance violated his 14th Amendment privacy rights. What Judge Harlan decided here was that while personal liberties were quite broad and powerful, they are not absolute. And that people do not have the right to be at all times, under all circumstances, completely free of restraint. Justice Harlan said that any individual may assert the supremacy of his own will and rightfully dispute the authority of any human government, especially of any free government existing under a written constitution. But it is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of individuals in respect to his liberty may at times, under the pressure of great dangers, be subject to such restraint and be enforced by any reasonable regulations as the safety of the general public may demand. So therefore, putting this into colloquial 21st century English, what Harlan means to say here is that as members of society, we have entered into a social contract. We agree to subjugate, under some circumstances, our individual liberties when necessary in order to promote the common good. And in exchange for that, we get the support and protection that society affords us. Harlan, in reaching his decision to uphold the Cambridge law, had to answer a couple of questions, and two of those were whether the safety of the public justified the restriction, i.e., the vaccination ordinance, and whether or not the vaccination was necessary and reasonable. And he answered those two questions in the affirmative. When there is a public health crisis, the court said it's the legislature, that's the organization in the Massachusetts government in this case, which made the law, it's the legislature's prerogative to determine how to control the epidemic, provided that it does not act in an unreasonable, arbitrary, or oppressive manner. And that is the heart of the 14th Amendment substantive due process. So, the Supreme Court upheld the vaccination law, and here we are 115 years later. And what does it mean? It's an interesting footnote in history for sure. Legal students and law schools across the country study this case at some point or another. But in the state of Texas, uh, in enacting its own laws to combat the COVID 19 pandemic, it comes up again under the principles of stare decisis, or um, precedent under our common law system. Let me review for you that our judiciary, when they make decisions, when our judges make decisions, they are relying upon the decisions of other judges in similar cases in higher courts decided before them. This is called stare decisis. It means to stand on the decision. It's sometimes called legal precedent, and it's part of our common law system. So that if I today were to have a case as a judge that involved a certain set of facts, before deciding that case, I would do the research, or I would have my law clerk do the research and try to find out whether some other court, a higher court in the jurisdiction of the state of New Jersey, had decided a similar case in the past. And if they had, I would read carefully the principle of that decision and apply it to the extent possible in my case before me. And this is what happened in Texas. The case is in Ray Abbott. I've given you a copy of it. I've also given you a copy of the Jacobson case in the materials for Module 2. In the state of Texas, Governor Abbott enacted um, a series of measures by executive order in the face of the COVID 19 pandemic. And what he decided to do in Texas, as many states also did, was to say that unnecessary or non essential surgeries would be halted for the time being, temporarily. And then the next task was to define what non essential surgeries were. Lo and behold, under the heading of non essential surgeries were abortions, both medical and chemical. The governor's executive order was challenged in the Texas federal courts as a deprivation of the 14th Amendment privacy right, citing, of course, the landmark case of Roe versus Wade, which established a woman's right to an abortion. There's no doubt that in this pandemic, our healthcare system has been strained to the breaking point, and therefore it's not unreasonable to think that non-essential surgeries like plastic surgeries or elective surgeries should be curtailed for the time being so that the system could devote all of its remaining resources to combating the COVID-19 epidemic, pandemic. And to this extent, this was the rationale of the governor's order. Um, as the court in the Fifth Circuit Court of Appeals, which is the federal Court of Appeals, set about trying to decide this legal issue in Texas, they did their research, and lo and behold, they came up with the case of Jacobson versus Massachusetts. And on the strength of the holding in Jacobson versus Massachusetts, they found that the states do have the ability to enact all reasonable uh, uh, regulations and orders and take measures necessary and reasonable to combat a public health crisis, as long as they're not arbitrary, unreasonable, or oppressive. The debate in Texas finally came down to whether or not surgical and medical abortions should be treated in the same way, in the sense that one or the other may take more or less, may require more or less PPE or other hardware and resources also needed to combat the pandemic. Ultimately, the parties worked out their differences before the case was decided in the United States Supreme Court and decided that chemical abortions could proceed, whereas surgical abortions would be temporarily curtailed. Um, it is true that this case was a hot button because of the manner in which it touched on abortion as a basic right under the 14th Amendment, and the fact that the state of Texas, along with many other states, have attempted over the last few years to find one way or another to chip away at the rights conferred by the Roe versus Wade Supreme Court decision from 1970. So, in some circles, it was felt that the Abbott executive order, as it related to abortions, was really just using the pandemic as an excuse to try to erode the woman's right um, to abortion. Of course, even the governor's executive order held that if an abortion were medically necessary to preserve the life of the parties involved, then of course it could go forward. So, very interesting, and I bring up Abbott only in the sense that it's proof positive, if you didn't believe me before, that a modern court would look back at a Supreme Court case 115 years old to help it decide a modern issue. Public health police powers, then, as we think about Jacobson and Abbott, um, will be upheld when it's found by the court that they are necessary, reasonable, and proportional. That is, no more restrictive than is necessary, and that they avoid harm, meaning that in the case of Jacobson, we would not be permitted to vaccinate Jacobson if he did not want the vaccination. Back in our history, there was a time when certain prisoners would be subjected to forced chemical sterilization. This was held to be unconstitutional by our courts. This is the principle of bodily privacy and decisional privacy as well, although in prison, prisoners do not have the sort of autonomy that gives rise to having any kind of decisional power. They basically give that up when they are sentenced to prison. So the principles of Jacobson is, first of all, it shows us a little bit about separation of powers. We see the legislature in Massachusetts acting and Cambridge Town acting with its vaccination ordinance, but then we see a citizen protesting it and filing a legal case to challenge it. And we see that the judicial arm of the government, the judicial branch in the Massachusetts Supreme Court and ultimately the United States Supreme Court, gets involved to decide whether or not the legislative action was constitutional. And we learn that the courts will give deference to the legislature to make certain judgments as long as they're not arbitrary, capricious, unreasonable. We see federalism in action in the sense that even in Jacobson, it was the state which acted under its police powers, not the federal government. It was a state law, not a federal law. And we see the principle of social contract, which is that basically, even in the absence of laws and courts and judges, individuals, by agreeing to subject themselves to the laws of a society, are entitled to the protections of that society. So Jacobson is still good law 115 years later, and I suspect it will still be good law in 200 years. So let's pay attention as we move forward to cases which may be moving their way through the courts on COVID-19. And I suspect in the fall or later, when the vaccination for COVID is developed, we'll have another blossoming of protest against vaccination. Those people who don't want vaccinations or believe they're bad or immoral or violate their religious principles will once again use the courts as a forum to redress their grievances against the vaccination laws, which will inevitably result. I mentioned up front that this course, public health law and ethics and health law and ethics, is a cross-listed course, and you're getting 2 for 1, but maybe you're getting 2.5 for 1 in the sense that I want to give you some of the tools which will enable you to read and understand a judicial decision. And I've given you in your resources for Module 2 a wonderful article written by a George Washington University law school professor named Oren Kerr back in 2005, which was designed as a guide for brand new law students to figure out how to read judicial decisions. Now, of course, as law students, they will do a lot more of that than you ever will. But given that this was an article given to recent college graduates seeking a career in the law, the readers of this article would not have had any special expertise as they read this article for the first time. So what I want you to do is to take a look here at the Jacobson decision, and we'll use that as an illustration as we go through. And all judicial decisions are compiled into volumes or reporters, as we call them. The Supreme Court has the Supreme Court reports or U.S. reports. There are actually 2 sets of books which compile those. But each court is basically has its decisions published in a set of books. These books go back to the dawn of the Republic. The decisions have been written down and are archived in these books, and now online as we rely less and less on hard copy books in 2020. But they're there so that under the principles of stare decisis and precedent and our common law system, our judges have the ability to go back and read these cases and do the research which will inform their decisions on the cases that are before them today. First thing you notice when you look at a decision is the title of a case. So the title of the case is called the caption, and it tells us a couple of things. It tells us who the parties to the case are, first of all, and In the case of a civil action, remember we have civil cases and we have criminal cases. In criminal cases, the first party is generally the government. It could be the United States of America. It could be the state of New Jersey or any other state, which is the prosecutor in a criminal action. And the other party is called the defendant. In a civil case, we have a plaintiff, which is the person who is asserting the claim, and we have a defendant, which is the person against whom the claim is asserted and who is in the position of defending against the lawsuit. So we look at the caption and we see that Henning Jacobson is the plaintiff here, and the Commonwealth of Massachusetts is the defendant. And that makes sense because he was challenging a state law. The next thing we see is a case citation, and this is very important because this tells us which court the decision comes from and what volume and what page we can find that decision on. So a Supreme Court case would be in a reporter called U.S. Reports, and the citation also tells us what year it was decided. So this is important, and here, if you follow my cursor, you can see the citation for the Jacobson versus Massachusetts case. The lawyers for the parties are also identified below the caption, and in the case of some decisions, there'll only be two lawyers, one for each party. But where there are more parties, there'll be more lawyers. Where a case is very, very notorious or important, we'll also get parties writing briefs and participating in the case who are not technically parties to the case. We call these people amicus curiae, friends of the court, literally in Latin. And they appear with the permission of the court for the purpose of letting everyone know that they think the issue is important and to help the court, to aid the court through legal reasoning enunciated in their briefs as to what they think the outcome ought to be. The author of an opinion is the judge. In Supreme Court cases where in the U.S. Supreme Court we have 9 justices, one will be assigned to write the opinion. If the court is unanimous in its decision in a given case, then the court will the author of that case, that judge will write an opinion, and that's all you will see. However, occasionally, and quite often actually, other judges on the court may agree on different reasoning or even disagree with the decision written by the author of the opinion. And they can write separate opinions. So the primary author of any opinion, we would say, is the author of the majority opinion. And this is basically the law of the case. This is the decision which will bind that court and future courts. After that, we have concurring opinions by other justices. They may agree with the result arrived at by the majority opinion, but they disagree with the reasoning, or they want to add a note of explanation. So they will write a separate opinion, which is called a concurrence or a concurring opinion. And then finally, we have dissenting opinions. Occasionally, and quite often with our current Supreme Court, which is really split on ideological lines, we will have a justice or more than one justice writing a dissenting opinion, disagreeing quite forcefully with the majority opinion and explaining their reason for disagreement. Next, we'll see a statement of the facts of the case. And this is something that I would think as you read decisions, and I hope you will do so, you will focus on. I wouldn't want you to dive into the really thick and boring legal analysis that the courts sometimes indulge in, but I think it's important to understand the facts which are before the court. And so the facts of the case are usually laid out in quite good detail because it's from those facts that the judges will then apply the law, the decisions of other courts, the statutes which apply to come to their ultimate conclusion. After the statement of the facts, normally we have something that not mentioned here, but procedural history where it explains how the parties managed to get the case this far to this court. And that has more to do with the procedures of the courts and the different um, uh, levels of court that the parties have been through before they ended up before the Supreme Court, for instance. The next section is the law of the case, and this is the part that I'm going to absolve you from. This can be rather thick and technical, but basically, here the judges are, having done the research, are applying the law as they understand it to the facts which they described above. And then we have the disposition, and disposition is the decision. This is where the judges, having considered the facts and having researched the law, decide the case. They explain how the law relates to the facts. They decide how the case is going to come out. They explain it. Some are better at explaining it than others. And it's there for future judges and for people who are interested to read and understand how, under a given set of facts, a case was decided. The disposition, of course, in the Jacobson case was that the Massachusetts law and the Cambridge Ordinance were valid. Concurring and dissenting opinions we described just previously. Look for those. Those are always interesting because you might read an opinion and say, wow, that sounds quite reasonable to me. How could anyone conclude otherwise? And under those circumstances, I would invite you to skim the dissent if there is one and see how another very astute judge might see the same facts differently and the same law differently. So be careful to understand the facts and, of course, to understand the conclusion because it's the conclusion which is the law. And the law may, to one degree or another, be your guide as you move forward in your careers. You may find yourself in a position where you're a decision maker or a policy maker, and your decisions and your policies in the public health or healthcare field will have to be informed by your understanding of the law. To be sure, any organization you work with will have access to competent legal counsel who will be public health law specialists or healthcare law specialists or ethicists, people who are experts in trying to figure out in a difficult situation what's the ethical outcome. But it's not a bad idea for you as a policymaker or a decision maker to have a good, firm grip on understanding the legal principles that govern your field. For your assignment for week 2, I'd like you to read chapter 3 in public health law and answer questions number 3 and 4 at the end of the chapter on page 95. Your answers will be submitted through the provided Dropbox in Module 2. I want you also to read the article on how to read a judicial opinion and also Not Your Great Grandfather's Public Health Law, an article which really describes the Jacobson versus Massachusetts opinion and its continuing impact in the law today. And of course, we'll have a forum. There is a TED Talk, which I'd like you to watch, and that'll serve as the basis for your forum response this week.